Hello, I'm Los Angeles City Controller Ron Galperin, and I'm so pleased to be part of the LA Public Library's continued work to promote financial literacy. All year long, the library, through its outstanding Department of Lifelong Learning, hosts life-changing programs that teach and support financial empowerment, immigrant integration and inclusion, and health and wellness. And the best part of it is that it's all free. As controller, I make sure that public dollars are being put to good use by keeping our government honest, responsive, and accountable. Because people want to know and deserve to know that their government is doing its best to serve them. While it's important for the city to plan how to use its money wisely, I want you to know that it's just as important for you to do the same. Because the financial health of the city depends on the financial health of all Angelenos. The programs that the library is hosting this week and throughout the year are here to help everyone succeed and to make a positive financial choice for their future. I am so grateful for all our libraries and the incredible staff and VITA and EITC financial experts and all their volunteers for all they do to ensure that you and your families have the tools and resources not only to prepare your taxes, but to help you be on the right financial track. Thank you.
Hi everyone, I'm Caroline Zakarian and I work for the Office of Savings and Community Services here at the Los Angeles Public Library. Welcome to Financial Literacy Month. Today's program is called Estate Planning and it's brought to you by Bet Tzedek in the Los Angeles Public Library. Today, Elisa Anderson and Taylor Amstutz from Bet Tzedek will show you why individuals need an estate plan and highlight some of the basic components of an estate plan. We'll have a brief Q&A after the presentation, so please send us your questions throughout the program. Thank you very much, and take it away, Taylor.
Hi, everyone. Thank you so much for joining us today. I'm thrilled to be here with you all. My name's Taylor, and I'm an attorney with Betsettic Legal Services. But right now, I'm focused on elder abuse intervention through an Equal Justice Works Elder Justice Program Fellowship, which that mouthful is really just to say that I'm focused on elder abuse intervention through elder abuse restraining orders, advanced planning or estate planning, conservatorships, and community education and outreach. So as I mentioned, I'm really looking forward to being here with you today and talking about advanced planning. Specifically, I'll be talking about capacity to make decisions in the context of advanced planning before I hand it over to my co-presenter, Lisa Anderson. So without further ado, I do want to mention we want to keep this interactive. So if you have questions, please feel free to put them in the chat if that's an option. But we will also have time at the end, and our contact information is included in the last slide, and you'll be provided with the slides. So if you are interested in maybe speaking with someone about advanced planning further, we would be happy to discuss that with you, and our contact information can be found at the end. So we can't really talk about advanced planning without first discussing legal capacity. So what is legal capacity? Formally, it's defined as a person's ability under the law to engage in a particular undertaking or maintain a particular status. Oftentimes, capacity and competence are used interchangeably, but today we're just going to talk about capacity. And a legal capacity to do a particular thing really depends on two factors. So first, it's an individual's cognitive functioning, and second, the gravity or seriousness of a decision. So these two factors have a direct relationship. As the gravity of a decision increases, the level of cognitive ability or legal capacity also increases. So for example, the capacity needed to enter into a multi-million-dollar contract is obviously a lot higher than that which you would need to maybe sign up for a weekly newspaper or magazine. Of course, if you have capacity, you are still completely entitled to make bad decisions. Everyone has the right to make stupid decisions, for lack of a better term, as long as they have the cognitive ability to do so. So legal capacity is really more accurately thought of as a continuum, as you see here on the slide. as opposed to an on-off switch. Oh, there it is. Okay, perfect. Which it had previously been thought of before. So previously, if someone received a diagnosis of Alzheimer's, they would be determined to lack capacity automatically. However, now, as I mentioned, it's more of a continuum. So capacity determinations now need to be based on evidence of a deficit. So someone who is suffering from a cognitive disorder may still be able to perform a variety of actions with legal consequences. So here we just have a list of common scenarios where we often see elder abuse and legal capacity overlap. Almost every elder abuse case involves a capacity analysis because we need to know whether the victim was able to make their own decisions at the time that they made them. So a few examples, we'll say that Sam recently put his caregiver's name on his bank account so she could help him pay his bills. He also made this caregiver the beneficiary of his life insurance, his retirement, and his bank accounts. Previously, the son had been named the beneficiary of those accounts, so he calls Bet Tzedek and he is not happy. Another example, let's say dad met a woman about a year ago who she quickly moved in with him. Family was a little alarmed. He recently went to an attorney and created a trust, giving this new girlfriend power to make decisions for him and leaving his house to her after he dies. So both of these examples are situations that could easily be either instances of elder abuse or undue influence, which we'll talk about in just a moment. Or depending on the elder's legal capacity, they could just be decisions that they've made that they are completely and entirely capable of making. So the fact that your family might be upset by a decision doesn't mean that there's a capacity problem. Next, we have our civil legal standards of capacity, which is kind of a lot of jargon just to say that there are different levels of capacity required for different instruments. And we're going to talk about our advanced planning or estate planning tools throughout the presentation. And here's just a summary of the capacity required to execute a few of these documents. So in order to execute a will, you need to have an understanding of what you own, so your property, your personal assets, etc., and to whom you would like it to go upon your passing. For an advanced healthcare directive, which can also be called a power of attorney for healthcare, you need to understand the nature and consequences of a decision and then be able to make and communicate a decision. And then for a contract, power of attorney, and trust, the standard is a bit higher. It requires that you understand the nature, purpose, and effect, or the consequences of the terms that you're going to be putting in place. So, as I mentioned earlier, undue influence is a big component in elder abuse cases, and I do want to touch on it as we discuss capacity today. So the California Welfare and Institutions Code defines undue influence as excessive persuasion that causes another person to act or refrain from acting by overcoming that person's free will and results in inequity. So undue influence occurs when the influencer uses their role and power to exploit the trust, dependency, and vulnerabilities and fear of another. They use this power to deceptively gain control over an individual's decision-making, often for financial gain. Undue influence involves the influencer using improper and exploitative persuasion. So when some people have the cognitive skills to make financial decisions, they may also be susceptible to this undue influence. So in the examples that we talked about earlier, if the caregiver or girlfriend used excessive persuasion, including exploiting their role, so especially in the caregiver scenario, if they were using that to then pressure this person into making decisions that they really didn't want to make, and that resulted in an inequitable outcome, then that could be an instance of undue influence. So for many reasons, it's important to have a surrogate decision maker. And I'll use this term a bit here, so I do want to clarify what it means. When a person lacks capacity to make a decision, a surrogate often assumes authority, which just means they step into the person who no longer has capacity. They step into their shoes and speak on their behalf or make decisions on their behalf. So what this person who steps into the other individual's shoes can do depends on a number of factors. So here you see in my slide, under informal, it is blank. That is not accidental, although it might look like it. This can really take many forms. So informal surrogates are often practical, stemming from a pre-existing relationship. These are easy and there's no cost to establish this informal agreement, but there's really no protections for the principal, which is the person who is granting the authority. So spouses, children, and friends who step into decision-making for these clients who've lost capacity, and they've never made a formal nomination, which we'll get to in just a moment. So if the decision is routine and the client doesn't object, then informal surrogates can manage a great deal. But as I mentioned, there's not a lot of protection for the person who's granting this authority, because there's not necessarily a fiduciary duty, which just means that you are required to act in the best interest of the person who's given you that authority. So in the context of a power of attorney, which we'll talk about in a moment, there is a fiduciary duty to the person who's given you that authority, that you need to act in their best interest. So here under formal surrogates, you'll see power of attorney at the top, who's appointed by the client or through some other legal process, such as these advanced planning tools that we're going to talk about. But the most common is the power of attorney for health and finances. I think it's really important to note at this point that setting up these documents, so a power of attorney, an advanced healthcare directive, a trust, it doesn't mean you're giving up your self-determination. It's really just planning ahead to make sure that you have agents in place to speak for you should you need it. And then also making sure that those people you've put in place know what your wishes are. So these are the four main advanced planning tools. This slide is kind of a helpful visual representation of the two areas that advanced planning documents cover, and then how those documents fit in. So as you can see, the power of attorney for finances is only used during a person's lifetime. So it terminates at death. And this is given in cases where an individual wants someone else to either make their financial decisions immediately or upon finding that they've lost capacity. A common misconception that we often hear is people are calling and they're trying to deal with things that are happening after someone has already passed using this power of attorney. And unfortunately, as mentioned, the power of attorney is not effective once the person who executed the document has passed. So on the other end of the spectrum, you'll see that a will is only effective after death. So it means nothing before you die. And if I were to write a will today, giving you my house, I can actually just go ahead and sell that house tomorrow and you will get nothing. Or I can give that house to Lisa tomorrow and leave you nothing. Or my will today can say that I'll give you $1 million at my death, but if when I die, I only have $10, then that would be all that you get. So being in someone's will doesn't give you any authority or rights until the person has passed. An advanced healthcare directive or power of attorney for healthcare is a bit different. It mostly operates as a power of attorney for finances does, but in the healthcare context. So giving authority today to make healthcare decisions while the person is living, and the right terminates upon the passing of the person who has given that authority. However, you do have the option to leave some post-death authority in your advanced healthcare directive. So for example, if you wanted to authorize an autopsy or the right to donate remains, and the right to decide what to do with those remains, that's something that can be accomplished through an advanced healthcare directive. And a trust, on the other hand, you'll see is kind of in the middle there. It operates a bit like a will and a bit like a power of attorney. So you can use a trust to set up choices both during and after life. And often the difference between a power of attorney and conservatorship can get a bit confusing. So I do just want to provide a bit of clarification there. A lot of times people become confused when they're trying to handle their parents' affairs with the bank, doctors, landlords. And often they'll hear, you need to get a power of attorney to do that. People often call us and say, I need a power of attorney over my mom because she has Alzheimer's and I need to get access to her bank and pay her bills. So part of my job is to then ask the caller about mom's capacity and explain the difference between a power of attorney and conservatorship. So in this example, the mom has to be the person who gives the daughter power of attorney. She needs to be able to communicate her desire to give the power of attorney to her daughter and then understand the consequences of giving the daughter that power of attorney. So if mom isn't able to do that and she can't execute a valid power of attorney, then I'd have to tell the daughter that she needs to ask the court for an order giving her the authority to make decisions for her mom through conservatorship. So only a court can grant conservatorship if it finds that mom has lost the mental capacity to execute a power of attorney. It's really kind of an inconvenient and lengthy process to go to. So it's really important to execute a power of attorney in advance. Again, it's not giving away your self-determination. You are certainly more than able to change that document, but it is really essential to put in place a power of attorney because it really gives more self-determination. A conservatorship of the person is established when someone's unable to provide properly for his or her own personal needs for physical health, food, clothing, or shelter. And someone can establish a conservatorship of the estate if it's found that that individual is substantially unable to manage his or her own financial resources or to resist fraud or undue influence. So we do have information on our conservatorship clinic later in the presentation, but I hope that this very brief overview gave you sort of a general understanding on the topics that Elisa is going to go into further in part 2. So thank you all for your time and attention today, and Elisa, take it away.
Great. Thank you so much, Taylor, for that informative information. Every time I hear it myself, I make notes and think of other things I need to be talking about as well. I will do, my name is Anderson. I am Bet Tzedek's Elder Abuse Prevention Advocate. My role is to go into the community, educate first responders, community seniors, caregivers as to what abuse, the components of elder abuse, and how it correlates with prevention and techniques, which includes advanced. Prior to going into the slides, I do want a little bit about a quick overview for those of you who may know. So who is Bet Tzedek? Bet Tzedek is a nonprofit firm. We provide free, comprehensive legal, administrative representation, volunteer and court-based services, and legal education. 90,000 people each year. We keep families in their homes, secure care for those with physical, developmental, or intellectual disabilities, protect seniors from abuse and real estate fraud, and ensure access to safe housing and legal wages, is obtaining guardianships for children to stay in homes. Betsettic Services, we use direct legal services, impact litigation, community outreach, and legislative advocacy to assist individuals throughout the LA County. We've assisted 95,000 individuals in 2020, as same amount in 70% of Los Angeles County's conservatorship services are held through our no-cost clinic, which I'll have more information on that. And over half of Betsettic over the age 60, with 1,300 volunteers averaging annually assisting us to complete these services. Last but not least, we've been around more than years as a provider of elder law services in the city and county of Los Angeles. We are nationally recognized as a in providing information for seniors. Today, our focus is on the Elder Justice Unit, which Taylor has presented some information on. Our unit talks about conservative elder abuse restraining orders, financial elder abuse, real estate fraud, in-home support services and other administrative hearings, Medi-Cal estate planning, power of attorney for finances, wills, and more. With that, right into presentation. So, advanced planning tools. What do they consist of? So, as Taylor mentioned, advanced healthcare directives. We also have our power of attorneys for finances that we'll talk about today, wills, trusts, transfer on deed, conservatorships, and more. Advanced Healthcare Directive, which you've already heard, but we'll just reiterate, it's a legal document that allows us to make decisions now for healthcare treatment in the future if and when he or she is unable to make those such decisions. With the Advanced Healthcare Directive, you choose agent, as we discussed earlier, you express wishes for your future. There are 2 witnesses required. It is a revocable document. There's no statutory on this. Powers and limitations of the healthcare agent. They're able to receive confidential medical information and make healthcare decisions if the elder is unable. Keep in mind, not make decisions if the elder disagrees and cannot control the elder's contacts. Power of attorney allows you to grant an agent the authority to manage your finances. So you can grant your daughter to manage your finances, which may be accounts, estate, insurance, retirement, and more. Power of attorney finances, which means you're able to appoint the agent, the agent's authority, what they can and cannot do. The is revocable, the potential for abuse, and there are some limitations as well. And prohibitions of financial agents. They keep the property separate, use assets for elders' benefits. They cannot use the assets for themselves unless the document allows such, and cannot commit fraud on the elder. So, sample terms of a power of attorney. This power of attorney shall take effect upon my capacity. My capacity shall be determined by my primary care physician in writing. So that's one phrase that you may see, or it could say, the power of attorney will continue to be effective even though I become incapacitated. So there's different terms that can be used in setting up your financial power of attorney. Wills. Wills is, of course, as we know, a legal document, irrevocable upon death. Does beneficiaries to receive certain items and things that you'd like to pass out to different people or organizations. And there's several types of wills as well. And then you have your probate assets and the no will interstate. And again, these are quick views as what estate can include. Next slide. So what is a Taylor kind of talked about a trust. So the most trust is a legal document, places your assets, bank accounts, real estate, personal property, etc., in a trust for your benefit during your lifetime, and where things are to go upon death. In other words, you may be claimed as the trustee on your parents' trust account, and with case, you are then able to handle banking affairs, pay their real estate, and so on and so forth. So you can transfer to the name of the trust, but retain control of your assets. So in other words, if it is my mother's trust becomes in her name, Sally Smith Trust, with her address or whatever assets. So it's in her name. You can revoke the trustee at any time during your life. So at any time, my mother can say, I don't want you as a trustee anymore, and that can be revoked. So it's not a lifelong decision. You can also name a successor trustee who will be your relative upon death and transfer your assets directly to your beneficiaries according to your wishes without court involvement. So these are some of the reasons why a trust would be a good idea. As we go throughout this pandemic phase in our life, there were multiple people that unexpectedly fell into a health crisis, and these documents may have been available or for those that are out of date, and families had difficulties in trying to assist their loved ones with health decisions, asset protection upon death, and so forth. So things that we all should be looking at and wanting to in making decisions in the future. Next slide. So trust, again, management during your life, cemetery after death, the settlor, the person who trusts, trustee manages the trust. So the settlor, creates this through an attorney with the wishes that to have, appoint as the trustee, and the successor trustee is a person who manages the settler's death or incapacity. So those things can be decided up the trust in either direction. So again, powers and limitations of successors and trustees, effective on incapacity or grantor, powers listed in the document duty. So the document is very clear as to who does what, when, and how. So no self-dealing unless allowed, no returns of the trust, and no controlling contacts. Those are the things that are not allowed for the trustee during the next slide. Abuse by an agent or fiduciary individual. So there are several civil remedies that one can use as far as suing someone or what have you that did the wrong thing according to the trust documents. There are some ways to collect money. There are also criminal with Penal Code 358, embezzlement, forgery, jail, and fines. Next slide. So conservatorships, we'll just touch base on conservatorship with everything else. So of course, a limited probate conservatorship is when a judge appoints a responsible person called a conservator to assist an adult with developmental disabilities called a conservatee who is unable to provide for his or her own personal and or financial needs. A general conservator is just a conservator established for an adult who needs assistance of another party to handle their finances and affairs. General conservatorships are granted to those who are elderly or have been impaired by an illness or an accident. So we see this a lot of times, and that's what Taylor had mentioned earlier, where the daughter had to go to the judge to make a decision to if she will then have over the. And then you have your Alzheimer's order. And of course, we see that most frequent those that have to an Alzheimer's state of mind and are unable to handle their general affairs. And sometimes those just come so quickly without one knowing. And those type of orders we see on a regular basis. Next slide. So Betsettic does have a self-help conservativeship clinic. We used to do the clinic in person. Of course, since COVID, we are now operating remotely. If you like help or have questions in regards to conservativeship information, you can email Betsettic at ccclinic@betsettic.org, or you can phone them at 323-549-5863. You can also go to Betsettic's website. We do have a calendar at the top, which lists all the events for each month for the different services and clinics that Betsettic offers. Again, the clinic for conservatorship is self-help. I believe there's a questionnaire that you're able to download prior to receiving assistance from the clinic. There's a Q&A usually attached to that. And once you've done that, the clinic will assist you with the forms, the filing, and the notices. However, not with the representation, okay? The clinic cannot assist if you have significant assets as well. So those are just some general rules of conservativeship and how we're able to assist you. So anyone who needs that, please go on Betsettic's website or call the number previously stated to get that information, and we can help you from that moment. Next slide. So Safe and Savvy Senior Educational Series is a program that I am running at this time throughout LA County. Just wanted to bring it to your attention in the event that anyone is interested in having these types of presentations for your organization or more. With the Safe and Savvy Educational Series, I talk about what is elder abuse, not just during the coronavirus, but in general, knowing your rights of elder abuse in those. We have tips and prevention. We have advanced planning, prepare, which is what this is consisting of. We have our contractor fraud and PACE, which is property assessed clean energy, solar panel, paint that you never have to paint your house again. Those types of presentations, Medicare, and several more. Any information on programming that you need from Betsettic, you can contact myself or Taylor, and we can certainly try to get something for you. Right? These are just how the presentations that I just spoke that you can utilize. Set something up for you. And our next slide will be. Thank you so much. If you have any contact Betsettic, general information is 323-939-0506. Use that number to contact Betsettic, or you can self or Taylor directly. Our numbers and emails are here on this slide. If you have any questions at this time, we will be happy to answer those for you. And thank you so much for allowing us this time to give you limited information on some valuable services.
Thank you, guys. Thank you both. I have a few questions. What are some facts for not having an advanced healthcare directive for yourself and family members?
I'm sorry, you said some facts?
Yeah, it's displayed at the bottom of the screen. What are for not having an advanced healthcare directive for yourself and family members?
I'm not sure that I'm understanding the question, but you mean like some pros and cons maybe, or?
That's exactly.
Okay, sure. Yeah. So if you don't have an advanced healthcare directive, like Lisa mentioned, you won't be able to obtain confidential healthcare information, or if you are the person who is incapacitated, it may make it difficult for doctors to find someone to make a medical decision on your behalf. They can't legally allow just, someone because they're saying that they're allowed to. Like if it's not in writing, the doctors don't have a lot to go on. So it's really beneficial for decisions, maybe if you want to be kept alive for a long amount of time with extensive life-sustaining procedures, or if you don't, that's a really important thing that you can put in an advanced healthcare directive. I feel the need to clarify that just by having an advanced healthcare directive that selects, no, I don't want these extensive life-sustaining measures, it doesn't mean that they're going to pull the plug on you immediately. I think that's a common concern that people have, and that is not the case. It's just a very helpful instrument if you did not want to be kept in a vegetative state for a long time.
And let me make additional comments in regards to that. Just based on the last thing Taylor said. So what can happen is if you don't have that in place and with a person that kind of knows your history or your what have you, then it's left up to the medical providers then to assess and make decisions as to what they believe the best plan of treatment is for you. So sometimes, you or disagree. And here is a real life situation. COVID, a family member did not have their advanced healthcare directive, passed out from nothing major, but still passed out as their ambulance came, was taking them to the hospital. No advanced healthcare directive, so the ambulance would not to anyone, would not, other than general information, would anyone to go with this person and would not allow anyone to visit partially because of COVID, but more importantly, would not allow any information, or what have you in regards to that individual's care because there was no healthcare directive. And so those are just, something that kind of can happen to anybody and a reason to have it available in the event of an emergency or anything of that nature. And it can be a person, a car accident, anything like that. I have children who are over 18, I can't make those decisions if I don't have this document in place. So it's not just for elders, it's really one over 18 at this point.
Okay, thank you.
And
Go ahead, Taylor.
I just wanted to, I think we briefly mentioned it, but if you feel really strongly about the disposition of your remains, an advanced healthcare directive is a great place to make those wishes known. So if you want to donate organs or you want to be cremated, an advanced healthcare directive is a tool that allows you to do that. So not having that tool in place could make it difficult for family members after your passing if you haven't let them know what your wishes are. So that was the last thing.
No, thank you. I have one more question. Can a power of attorney or trust be used as a scam prevention tool? If so, and how and why can they?
Yes, good question. Lisa, you're our
So
scam
you can
expert. Do you want to go first?
Go first. So basically, those are one of the tools that we like to suggest as a scam prevention. So let's say you have a power of attorney and the individual is able to assist you with your finances and things of that nature. And so when you get the power of attorney, what one should do is submit the power of attorney to the banking organization, to retirement plan, to the county assessor's office, which are real estate or things of that nature. And part of that is in the event someone comes in and goes to the bank and they're trying to scam or take money without you knowing, then the bank can look on record and say, well, wait a minute, you have a power of attorney on file. It has, Anderson and, Sally Anderson, and you're neither of those people. So therefore, I'm not going to this request or this check or what have you. So that's just in one. That's the same thing with retirement. That's the same thing with real estate fraud. Someone, a caretaker, perhaps we see this frequent or hear this frequently, where a caretaker, says, here, sign this document. I'm trying to help you with all your paperwork and get everything together for you last time. And we're going to take care of everything for you. You sign the document, you're not or even understanding what it is. You've now signed a home, and this person then goes to refinance, take a sale or what have you, and the power return on file assessor's office that prevents all of it happening. Those are just some ways that Taylor can chime in on the things that she sees.
Yeah, that was an excellent answer. I don't have very much to add, but this is why it's so important to choose someone that you trust for your agent in your power of attorney or in your trust, because it really is powerful. You give them a lot of oversight into your life and the ability to make really important decisions. So putting someone that you trust in place is so important, so that they can help you make those decisions that are in your best interest, and then also protect you in instances where other people might be trying to exert undue influence or scam or anything of that nature.
And one last thing I'll add to that is power of attorney or trust, you have options. If you're looking at a attorney, it has like a 15 item checklist that you can pick and choose. I want over my bank accounts, but not over my retirement. I want you to be over this, but not over my real estate. So you can pick and choose what you're to do. You can also have more trustees. Have two trustees perhaps, and trustee A can do this, trustee B can do that. So those are some other areas and layers of protection that one can have. But as Taylor said, be very careful as to who you're selecting. Make someone you can trust, and making sure that the discussion, importantly, the discussion is clear between the trustor and the trust of either of these two documents. As with the healthcare directives, those conversations need to be had with those individuals directly, and a clear understanding for it to really work out as it should. So these are just some things that we have with some general information. If anyone wants any of these services mentioned, touch with myself or more so Taylor, because if you get in touch with me, earn it to Taylor. So yeah, get in touch with us. We'll get you lined up with an attorney or someone who can help you through the next process of these things. And I can certainly answer any questions for you that you may have prior to.
Okay, thank you. Let me see if we have more questions. Okay, those are the only questions I see coming in. So I want to say thank you again, both, for a great presentation. I learned a lot. And anyone, if they missed this, any of the program, it's recorded. It will be on our LAPL's YouTube page. So it's going to be on there indefinitely. So I'll probably check starting tomorrow. So like the whole thing will be on there. And then I wanted to let everyone know our next financial literacy program is coming up this week, this Thursday, April 21st at 12 p.m. It's called Hablando de los Ahorros, and it's going to be Los Angeles Alliance for Economic Inclusion, or AEI. They're going to talk about saving strategies and tips. This program's in Spanish, but next Monday, April 25th at 12 noon, they're going to have a budgeting program in English, and then they're going to talk about different saving and spending that you can do. Yes, a saving plan, spending when money is short. So more information on all of our Financial Literacy Month programs, you can go to lapl.org/Financial Literacy Month. And thank you again, both. This was a great presentation, and I hope everyone has a great rest of their day. Thank you, guys.
Thank you.
Take care. Thank you.